Corporations Part 2, Pre-Organization Transactions. So before we form a corporation or an LLC, we will have promoters. Promoters will procure financing and all other instrumentalities such as leases in order to start the business. So one of the testable issues here is a promoter's liability on contract. The promoter, remember, is pre-organization. So the promoter is personally liable if they sign a contract in the name of a proposed corporation, because that promoter is presumed to be a party to the contract. Okay, promoters, general rule, liability on contract. The promoter is personally liable if he signs the contract in the name of the proposed corporation because the promoter is presumed to be a party. Okay, let's repeat that rule one more time. The general rule is that a promoter is, that's right, personally liable if he signs, that's right, a contract in whose name? That's right, in the name of the proposed corporation, because he is, that's right, presumed to be a party to the contract. Now, let's go to the exceptions to personal liability. There are 4. The promoter might not be liable if there is 1, clear contrary evidence, 2, a novation, 3, indemnification, and 4, adoption. Let's cover exception 1, clear contrary evidence. A promoter will not be liable on contract if there is clear contrary evidence that the person who is contracting with the promoter knows the corporation is not yet formed. The clear contrary evidence exception is if the person knows that the corporation doesn't exist yet, the promoter will not be liable. Okay, clear contrary evidence. Promoter is not liable when? That's right, when the person who's contracting with the promoter knows the corporation is not, that's right, yet formed. That is the clear contrary evidence exception. Exception number 2, novation. Remember, a novation does what? Switches parties. So if there's a novation of the contract between the promoter and the corporation and the third party, that's going to release the promoter from liability. So a novation will release the promoter from liability. Novation by who? The corporation or the third party, relieving the promoter of liability. So we have 1, clear contrary evidence. The promoter, the person contracting with the promoter knows the corporation hasn't formed yet. 2, novation of the contract by the corporation or a third party. Exception number 3, indemnification. Easy. The organization acting in good faith and not violating any of those fiduciary duties. And finally, 4, the corporation can adopt the contract. How do we adopt a contract? Well, of course, one can do so expressly. But remember, adoption is like ratification. If the corporation receives the benefits of the contract or accepts the services of the contract, and they do so with knowledge of all material facts, then that contract has been adopted or ratified by the corporation, and the promoter is not personally liable. Okay, what is our general rule? The promoter is, that's right, personally liable on contract if he signs the contract in whose name? The corporation's name. Why? Because he's presumed to be a party. Then we have our exceptions. 1, that's right, clear contrary evidence. 2, that's right, novation. 3, That's right, indemnification. And 4, that's right, adoption or ratification. Let's talk exception 1, clear contrary evidence. The promoter's not liable if the person contracting with them knows what? That's right. That person knows the corporation isn't formed. There's clear contrary evidence. The person knew that they were dealing with an unformed corporation. This will relieve the promoter of liability. Number 2, novation. Easy. The corporation or a third party executes what? A novation. And it releases the promoter from liability. 3, easy. Indemnification. The organization may choose to indemnify the promoter, depending on how the promoter behaved. And finally, adoption or ratification. Easy. Express or, that's right, implied. What is implied adoption? Well, you can adopt a contract impliedly by receiving the benefits, that's right, of the contract, or accepting the services of the contract. So, one little wrinkle in this, to ratify a contract or to adopt a contract, do you have to have knowledge of all material facts? Yes. Okay. General rule, the promoter is personally liable if he signs a contract in the name of the proposed corporation because he's presumed to be a party. There are 4 exceptions. 1, clear contrary evidence that the person who's contracting with the promoter knew the corporation had not yet formed. 2, the corporation or a third party executes a novation, releasing the promoter of liability. 3, indemnification. The organization may indemnify the promoter in its articles of incorporation. And finally, adoption. Express, easy. Implied, they received the benefit or accepted the services of the contract, and they have to have knowledge of, that's right, all material facts. Okay, so who do these exceptions exist to protect? The promoter? Not always. The exceptions exist to protect people who are acting in good faith, believing all the required corporate filings were made. So that's why a promoter is personally liable if they sign a contract in the name of the proposed corporation. We are trying to protect people acting in good faith who believe that all required corporate filings were made. One more rule. The promoter, remember, is personally liable on contract when they sign in the name of the proposed corporation because they are what? That's right, presumed a party. All right. The promoter is also personally liable if they sign a contract and they have actual knowledge that there's an incomplete filing or that they haven't filed. So in other words, the promoter is going to be liable if they go into a transaction knowing that there's a deficient filing or no filing, and they sign a contract on behalf of the corporation anyway. Remember, those exceptions exist to protect who? People acting in good faith, believing that all the requirements of corporate filing were made. They believed they were dealing with a valid corporation. The promoter will be liable if they know they have a deficient filing or haven't filed and they sign the contract in the corporate name anyway. Do the promoters have fiduciary duties to a prospective corporation? I think we know the answer to that. You bet. They have the duty of care and the duty of loyalty. Duty of care, don't act with gross negligence, don't act recklessly, don't violate positive law. Easy. And the duty of loyalty, to put the prospective corporation's interests ahead of one's own at all times. Don't compete with the prospective corporation. Don't take a business opportunity as your own, Mr. Promoter. Okay, what are the fiduciary duties for the promoter? The promoter's fiduciary duties to a prospective corporation are, that's right, the duty of care, and 2, the duty of loyalty. Finally, we're going to cover the subscription for shares. How do we finance corporations? Well, of course, we're going to sell shares. A subscription for shares is simply an offer to buy shares before the corporation is formed. Investors buy shares or subscribe to shares before the corporation is formed. Okay, that sounds easy, right? It is. Guess what happens if you sign a writing saying that you are going to buy X number of shares of this prospective corporation? Are you bound? You are bound, and it is irrevocable for how many months? 6 months. If you sign a writing that you're going to buy shares of prospective XYZ, that writing is irrevocable for how long? That's right, 6 months, unless there's another type of agreement. And it is payable when? No, not when the 6 months have expired. It's payable on demand. So in other words, the corporation can call for payment. That subscription for shares, the money's payable on demand by the corporation. The only generalization we can make is that the call has to be uniform for all shares, all of the same class or series. Okay, subscription for shares, what is it? That's right, it's an offer to buy the shares before the corporation is formed. If it's in writing, it's irrevocable for how long? 6 months, unless otherwise agreed. And when is it payable? On demand by the corporation. The corporation may issue a what? Call for that money in exchange for those shares. And that's it for pre-organization transactions.